morning to everyone. Thank you for that gracious introduction, and good morning to our chair, fellow directors, members of the CCGI, and all our participants. I know that this is the last day of what I consider to have been an excellent week of corporate governance learning and sharing. Congratulations to the organizers and to the presenters. It has been as stimulating as it has been educational. So I am tasked this morning to present on the governance of corporate groups and conglomerates. In the limited time afforded to me of the myriad of issues which groups of companies may face, I will confine my comments to subsidiary governance, which has become a term of art over the last few years, given internationally the attention a number of cases have received where the courts have found creative ways to find parent companies and directors and officers responsible for the sins of their subsidiaries. Without a solid subsidiary governance framework, parent holding companies and officers and directors of both parent and subsidiary may find themselves inadvertently responsible for the actions of the subsidiaries. I intend to take you on a brief journey from the traditional approach to parent company liability to the current approach, which is what I dub stakeholder-centric, given the developments in statutes, regulations, case law, codes, and of course, the big topic of the day, ESG imperatives. These are all good governance initiatives, but maybe bad news for parent companies and directors and officers of same. I will, however, also give you some good news in the form of recommendations for safe harbor. But before I begin, I cannot help but give you a story of the latest development internationally with regards to a parent-subsidiary relationship. And it's chock full of all kinds of goodies that we would have to put our minds to. This is a story of, well, actually, when I was preparing for this, some of the developments had not yet happened. It happened this week. Some of you know of it. You know of the company Unilever, which owns, has subsidiaries to dealing with a myriad of things, including pharmaceuticals, health things, cleaning things, and so on. They also have food and those types of companies as subsidiaries. Well, the interesting thing is, some of you may know about it. One of their subsidiaries is Ben and Jerry's. And Ben and Jerry's, some of us know, is an ice cream, a well-known ice cream establishment, business, company. And one would have thought, wholly owned subsidiary, one would have thought that it was good corporate governance practice to ensure that Ben and Jerry's had an independent board of directors, which it did, and that they were ensuring that they could make decisions on their own. Ben and Jerry's as a subsidiary prides itself on having good social conscience and all of that. And they made a decision over a year ago, maybe, where they would stop selling Ben and Jerry's ice cream in the occupied territories, Israel, occupied territories, Israel, Palestine, the whole tension between the two. And they decided that they would, in good moral conscience, no longer sell in the occupied territories. Now, this was an independent decision of the subsidiary. Unilever then got quite a bit of backlash, that's the parent, from a number of states, a number of investors pulled out. Some of their prices, their stock prices went down by, I think it is 8%, and mayhem. Unilever decided that they would then move Ben & Jerry's into a separate arm of the company. Just this week, it has been reported that now they have sold Ben & Jerry's because of the backlash and because of the effect on the stock price, sold Ben & Jerry's, it is reported, to the person in Israel who was holding the franchise. And that's one. And the whole idea was that there was damage to the parent based on actions of the subsidiary. I'll go further. A day, I think it was yesterday or the day before, it was reported that shareholders of Unilever are now looking to sue Unilever, parent company, for the way in which they handled the decision of the subsidiary, and that, you know, that it was delayed, that they did not hear about it, that their share price was lowered, etc., etc. So I put it to you that the actions of a subsidiary can affect greatly the actions of the liability, whether it's reputational or financial. It may have an impact on the parent, even if things are done to ensure that these are separated. So very interesting development. End of story time for the moment. So my opening salvo, about 12 years ago in The Economist, reporting on a big parent subsidiary case in the UK, Chandler and Cape, if you need to know the case. And it was stated the limited liability company is the building block of capitalism, mobilizing resources for investment. But its central tenet that investors are not generally responsible for the liabilities of the firms they invest in faces growing challenge. A decision by the Court of Appeal stretches almost to breaking point the corporate veil that has protected parent companies from the sins of their subsidiaries. So subsidiary governance then is very important because we see that growing case law that looks to finding the parent company responsible for the sins of their subsidiaries. And I'm going to then look at the fact that many of these cases now, recently, since these move to find the parent responsible for the actions of their subsidiaries, we find that many of these cases are actually settled, which doesn't augur well for someone like me who needs to see what the courts decided and so on. We want to see it come to the end. But of course, a number of them have also been decided on jurisdictional issues. So subsidiary governance, as I said, is relatively new area of corporate governance. And the reasons for this, I think, the reason why it's changing in terms of parent being liable for the sins of their subsidiaries is that oftentimes the resources to satisfy any claim, especially where a subsidiary no longer operates, say in another jurisdiction or even in the same jurisdiction, the resources are usually with the parent company. And we have a myriad of cases on that, Adams and Cape, Uruguay, I'm sure I'm mispronouncing it, and Chevron, which I'll talk about, Ecuadorian case. Also, the parent is the company that may have benefited the most from the activities of the subsidiary and benefited from its demise. Okay, so that happens as well. And there's one case, Southern, which says that, you know, they looked at, or the courts looked at the subsidiary as the runt of the litter, but actually the parent and other subsidiaries benefited from the fact that that subsidiary was going downhill. You can use your imagination there. The directors and officers, thirdly, of the parent company may have been less than vigilant about the affairs of the subsidiary. And sometimes then you would wish to go after the parent company. So one, or the directors and officers of the parent company. And many of us know the Barings Bank case, which most of what happened out in, I think, Singapore. But the problem was that the parent company was not vigilant. I'll just add also that newer corporate governance codes now have principles and guidelines dedicated to subsidiary governance to protect parent companies, subsidiaries, directors, officers from this type of liability. Not where it is not earned, but certainly in terms of where it is inadvertent. So what is subsidiary governance and why is it important? The governance and oversight of subsidiaries subsidiary governance is twofold. The governance and oversight of subsidiaries and the relationship between the parent and their subsidiaries, and two, the governance of corporate groups. Why is it important? I already alluded to it, hence the story time at the beginning. You may have costly financial damage. The cost is litigation. The cost is the possibility of being found liable, damages, and there's a cost in settlements. When I was complaining about settlements, it's really because I want the jurisprudence. But of course, we have seen as that many of the cases are settled, again, at a cost. The second reason why it obviously is important is cost of reputational damage. This can be immeasurable. Unilever, every time I look, you see Ben & Jerry's, but you think Unilever. Our esteemed guest presenter, guest speaker, keynote speaker on Sunday, referred to the allegations that a subsidiary of Deutsche Bank had been involved in greenwashing. Of course, this is very topical because so many companies feel they have to meet a certain standard for ESG, and it's possible that then some of the data which is inputted may not be accurate. So these are allegations that every article I've looked at on this particular case says subsidiary of Deutsche Bank. None of us remember what the name of the subsidiary is. Interesting. So I just want to mention quickly, and I'm grateful to Professor Poonam Puri of Osgoode Hall Law School, my colleague there, who has done invaluable research in this area on behalf of the Canadian government. And she has reported from Amnesty International that many of the cases in the UK, Australia, US, Canada, where many of these parent companies of these multinationals, when we're speaking about multinationals, many of the cases have been settled. And this is since, say, 2012, 2014. It's about 10 years since this has been active. And the reason for it, obviously, is because of the things I've mentioned before. So I'll give you examples. BP Oil, environmental issues. Trafigura, environmental issues. That's the case with the Ivory Coast, and that had mental gymnastics, private international law elements. A Dutch company, I think it was a French waste on some other type of ship and dumped in the Ivory Coast. And the persons in the Ivory Coast affected by this sued the parent company, settled. Shell in Niger Delta, Barrick Gold, human rights issues in Tanzania, many of them environmental. Australia, BHP Billiton, environmental. US, Exxon, that's the Indonesia case. Chevron, the Ecuador case, which I'll talk about in a little bit. And Canada settled recently, Chuck Bay and Nevson. So these are really concerning because although they have not admitted liability, the fact that these have to be dealt with and can be hopefully avoided through careful subsidiary governance, it's important. I need to add that there is another headwind, which is that Amnesty International is seeking laws, you'll see it on their website, making parent companies liable for human rights abuses arising in their global operations. They also want to eliminate what we call forum non-convenience. That's in private international law. And that is where you look for the most convenient forum. Convenient is really a loose word. You look at all the factors to see where a case should be tried. They wish to eliminate that because that's another jurisdictional hurdle for those who are affected by the actions of a subsidiary. So look out for those. So let me take you briefly through the past and then what is obtaining now. I've alluded to it already. So for years, I have taught company law. Even when I was teaching, learning company law, I was in school, I was in England, I was everywhere in Canada. We all spoke about lifting the corporate veil to make a parent company responsible for the subsidiaries. And it was always a difficult task because the principle that each company, parent, subsidiary, other subsidiary, in a group of companies, each company is a separate legal entity. And therefore, you can't go after the parent company, possibly without saying that the parent and the subsidiary are one and the same. But it's a sacrosanct principle. And you find the courts grappling with it, especially in the context of parent subsidiary. And you'll find Lord Denning, of blessed memory, he was known for being creative with the law and tried to create law sometimes. And he created this thing called single economic unit. And if they were found to be a single economic unit where the profits were the profits of the parent and so on and so forth, you could lift this veil. All of that, of course, has been discredited since, but there were, what I'm trying to show you is that we've always made attempts to find a parent responsible or another subsidiary responsible for the subsidiary, for the actions of the subsidiary. But generally, fraud is really the only true situation where the courts will find or should find, that's my view, that the company, the parent, and the subsidiary are one and the same. That is, if they're using the subsidiary to avoid liability or to avoid an existing legal liability. Not good. So then they used to look for things like whether the parent siphoned corporate funds from the subsidiary. There was an overlap of directors and officers, profits of the subsidiary treated as profits of the parent, persons conducted with the business appointed by the parents, was the parent the head and brain, and so on and so forth. And of course, you see, if you're thinking about this, but isn't a parent supposed to do some of these things? Not siphon off, but aren't they supposed to have a policy? So we have a challenge. Fast forward, and more recent cases state that you're not to lift the veil, as I mentioned before, even when you find that the subsidiary was completely dominated and controlled by the parent, which you must, and that the subsidiary did not function independently, which you must, but that there must also be a fraudulent or improper purpose. And so we see more recent cases, Chock and Hudbay, 2013, in the Canada. Very important. It was talking about serious human rights abuses on staff in Guatemala by the subsidiary, well, by security staff retained by the subsidiary. And they said absence fraud, we're not lifting the veil. And I mentioned Yeguahe and Chevron, I'll call it the Chevron case. And they affirmed that the corporate veil, this is in the Ontario Supreme Court, will not be pierced unless you find fraud. But this corporate veil thing has caused a lot of concern anyway, because sometimes what the courts have done is reserve a right, even outside of fraud, to say, well, if for public policy reasons, we are going to lift the veil and we're going to find the parent responsible. And so it's not surprising that the University of Chicago Law Review claimed that the court's piercing seems to happen freakishly, like lightning. It is rare, severe, and unprincipled. We don't want to fall into that. Recently in Jamaica, we've had cases dealing with lifting the veil as well and with subsidiaries, and they've stuck to the traditional view that they are separate legal entities. And if you want the cases, UDC, Urban Development Corporation, that's Jamaica, and Jacitar, that's 2017. And of course, International Hotels Limited and PSP, which is reaffirmed that a subsidiary can actually claim land by adverse possession that is owned by the parent. Very interesting cases. My point is the sacrosanct, the sacredness of the separate legal entity doctrine is alive and well. So let's look at now, before I go on with my stories, and let you know what is happening. In terms of lifting the veil, we see that that is uncertain. So a parent company can feel safe, more or less, without allegations of fraud, from being found responsible for the actions of their subsidiary generally, because the courts will not lift the veil. However, what is the shift? The shift is that the courts are now looking at other ways to find parents responsible for the actions of their subsidiaries. One, finding that a parent or a holding company or a director or officer of a parent or holding company is a shadow director or a de facto director. Thank you, Faye Lopez-Collimore, for that reminder last week or the week before that that whole concept of de facto director may come to haunt you as well. And that was in the context of corporate secretaries. And so where the courts find that the holding company is actually a shadow director, so not named as a director, you can then nab them for a responsibility to those re the subsidiary. Now, I am aware that it is mainly Jamaica, maybe Cayman. We have the concept of shadow director, which we incorporated in our company's legislation. And this is coming out of the UK. So we look at UK cases to decide what is, who is a shadow director. And usually, as defined in the Companies Act, it is those who exercise control and influence over the company and on whose directions the directors and officers of the subsidiary, for example, would be acting. And of course, there's an exception for professional advice. The UK gives further exceptions regarding holding companies and so on. We don't have that. And if you don't have the concept of shadow director, you may even find that they are de facto directors. And I don't want to go through the whole list of requirements for de facto and shadow, but suffice it to say that you would have had to have held out yourself as a director that's for de facto and been relied on as a director. So you're not in hiding. Shadow director suggests that you are in hiding. You don't want that responsibility. You do not want that liability. And therefore you are not placed that way, but you are acting as such. And of course, there's case law around this. This can happen inadvertently, just a warning for parent companies, because then a parent company, if found to be a shadow director, is now faced with the full range possibly of fiduciary duties and duty of care and skill and any other duties found in legislation of the director of that company. There's some nuances. I don't have time to dig deeper on that today. We can talk about it another time. But it is very exciting for me as an academic, not exciting for a parent company who is at risk. I just wanted to point out a curious little section in the Australia's Companies Act. And of course, I'm only throwing this out here because some of us may wish to lobby for improvements in our corporations, our companies' acts on this matter and have more clarity on this matter. I believe that we were talking about prescribing things for the public sector. And I think it may be useful to have some certainty. But Australia has this curious little section that says, I just have to share it with you. Directors of wholly owned subsidiaries, this is in that context. A director of a corporation that is a wholly owned subsidiary of a body corporate is taken to act in good faith in the best interest of the subsidiary if A, the constitution of the subsidiary expressly authorizes the director to act in the best interests of the holding company. B, the director acts in good faith in the best interests of the holding company. And C, the subsidiary is not insolvent at the time the director acts and does not become insolvent because of the director's acts. This is a very interesting section. We can talk about it another time, but it's good to be aware that there are provisions out there which give an out, which seem to affect the separate legal entity doctrine. Okay, so that was one way, i.e., a recap, shadow directors and finding that a parent company is a shadow director or de facto director. That's one way or directors of the parent, finding the parent or directors and officers of the parent liable for the actions of the subsidiary. Another way, which is the dominant way I find in the last 10 years, is through tort law, by finding that there's a duty of care owed from the parent to the subsidiary. And I mentioned Shock and Hudbay. It's a 2013 Canadian case, and it was settled in 2020, although it had gone to court before that. And there were allegations of assault, rape, other human rights abuses by private security company of the subsidiary mining company. And they went after the parent company, and they said, you know, the court said, no, we're not lifting any veil, okay? Because it was not appropriate. But they found that there could be a novel duty of care based on reasonable foreseeability, proximity, and policy considerations of the parent. I'm pausing. Proximity of the parent was found by public statements made by the parent. They had corporate governance practices similar that were followed by the subsidiary. They had relationships with the indigenous people. I would have thought those were good things. It turned bad for the parent in the sense that those are the things that the courts looked at to say, well, you could have a duty of care here. Didn't end up finishing the case, and they settled. Garcia and Tahoe Resources, this is another Canadian case, says the test where a plaintiff presents evidence of corruption and injustice in the defendant's proposed alternate forum, the court may ask whether evidence shows a real risk that the other forum, where say the subsidiary is, will not provide justice. And so there were allegations there that persons were shot and injured by Tahoe's private security company in Guatemala. That case was also settled. Then there's a landmark decision, Supreme Court of Canada, Nevson, where Nevson had 60% ownership in a subsidiary in Eritrea. And there were allegations again of human rights abuses by companies to which subsidiary had subcontracted mining operations, which were controlled by the Eritrean government. The Supreme Court of Canada held that corporations can be held liable in civil law for breaches of international law, and that the act of state doctrine is not a bar to a claim. And then finally, penultimately, this Vendetta case, which is a precursor to the current Okpabi case, Okpabi and Shell, so I'll just call it the Shell case, in the UK. Vendetta held that a parent may assume a duty of care where group-wide policies are implemented and administered by the parent. Again, how many of us have parent companies where we wish for our subsidiaries to, well, which we implement and administer group-wide policies regarding our subsidiaries or on our subsidiaries? But they said that can be where they could assume a duty of care. Now, the big case, Okpabi and Shell, and this is live. We're hoping to see the court case this year, 2022. But of course, it went to court first on a jurisdictional point, which is whether it could even be heard in the UK. And this is dealing with 45,000 individuals who claim that the parent company, Shell, their standards and policies failed to protect the oil spills affecting the water and environment in their country, in Nigeria. And it was held that there's no general principle that exists that the maintenance of group-wide policies or standards by a parent company cannot give rise to a duty of care. So here we are again. Group-wide policies can give rise to a duty of care. They also said a parent may owe a duty of care to third parties regardless of control. If, for example, it holds itself out in published materials as exercising that degree of supervision and control of its subsidiaries, whether or not it actually does so. There were a number of other things that they dealt with, which I won't have time to get into, but this is a much anticipated trial. Now that they've gotten over the fact that the UK court can hear the case, we are now at the point where we will hear the merits of the case. The final way, so that's duty of care. The final way which we find the courts looking outside of lifting the veil to find a parent company responsible for the sins of its subsidiary is I want to look at is the Chevron case. And that's a 2015 case. And it found the Ontario court found, it went all the way to the Supreme Court of Canada on a jurisdictional point, but they found that they couldn't lift the veil. And that's because there was no fraud in having established that subsidiary in Chevron. By the way, they shut down the operations in Ecuador and the subsidiary that is, and they were sold. So, you know, this is where there was a judgment in Ecuador for $9.51 billion for the oil spill and so on, and all the damage to the environment and to the residents in that area. Now, there's a further problem. We have to confess early. Apparently, it is alleged, if not proven, that that judgment was obtained through some fraud. Apparently, it is alleged that the lawyers for the villagers were involved in some fraudulent activity in bringing the case, in bribing quote unquote judges, and so on, led to, I believe, a disbarment of one of the lawyers in New York, and so on and so forth. So that has been some of the problems which have plagued this case. But even though the Canadians recognized, the Supreme Court of Canada recognized the jurisdiction of the Canadian court, they could go no further with it. Again, it's interesting because now we see the courts recognizing jurisdiction a lot more readily, and that's under private international law. I mentioned to you that's mental gymnastics, which I love, but we, again, I'm going to, in the interest of time, move on. Just want you to get a flavor of what is happening. So I'm going to conclude in 3 parts. One, I'm going to look at then the challenges groups of companies face, since they need to balance expectations of investors, reputational risks, the group's commercial realities, evolving legislation, including ESG-related disclosure requirements, and of course, emerging mandatory human rights due diligence laws. Regulation. One of the main challenges. We have companies legislation, financial legislation like Banking Act, Securities Acts, Insurance Acts, Insolvency Acts, some statutes dealing with employment, tax, bankruptcy, insolvency, as I mentioned. These may impose potential liability on parent companies associated with the activities of their subsidiaries. Also, anti-corruption legislation, the long arm reach of, say, the UK Bribery Act or the US Foreign Corrupt Practices Act, or even the newer provision found in the Jamaica Companies Act. It says it's a provision on avoiding conflict of duty and interest, which we have followed from the UK Act, but it has tacked on to it an anti-bribery provision. Again, these provisions could impact parent companies or groups of companies in ways which we didn't appreciate before. Then another challenge is the level of regulation imposed on such organizations from different regulators in multiple jurisdictions. Our heads are spinning, of course. So regulation is one challenge. Another challenge is the broad definition of subsidiary. If you look at, and I just use Barbados, Trinidad, Jamaica, although I've looked at some others, Bermuda, Cayman, and so on, they all have this word to describe or to define subsidiary. You find the word control in there, but damned if you do, damned if you don't, because from the word control is used there to describe you, and then you are being measured on, I guess, true levels of control. You may find yourselves in a difficult position, especially when it comes to being a shadow director. And then other challenges in conglomerates or groups, conflicts between parent and subsidiary. Perfect example, Unilever. Conflict between subsidiaries. And then, of course, as I mentioned before, ESG. And ESG, to be honest, I get a moment, and I'm going to turn into my father right here and now, where you have to get it in there, even though it may not be fully related. ESG, I argue, has always been with us. We've always in governance looked at environmental, aspects of governance. We've looked at social, we've looked at CSR, we've looked at sustainability, corporate sustainability. We've looked at all of these things. And of course, in governance, and we've looked at diversity on boards and all of the above, well before this established imperative of ESG. However, the difference now is that it is being measured. So it is not unusual for parents to set the tone with group-wide policies so as to not run afoul of ESG imperatives, but may put the parent at risk for liability of subsidiaries' actions. And I would argue that even the Deutsche Bank case, with the pressure, we can't have it both ways. On the one hand, the parent wants to say, yes, me and all my subsidiaries, I and all my children, as for me and my house, we're all doing the right thing. We want to say that, but of course, here it is that these may be used against you. Public representations, statements in press releases, websites, news conferences, all of these can be used to find parent liability, especially in the context now of ESG. So as I conclude, recommendations. I have 2 more minutes, I hope. Kamla, just still.
Yes, absolutely. Go ahead.
Thank you. Thank you. Recommendations. 1, conglomerates and groups of companies should assess the risk of personal exposure of directors and officers, the risk of legal and regulatory compliance failure, and the potential for unauthorized commitments and greater tax, commercial, and operational risk. But another recommendation, we should look at requirements for a subsidiary governance framework to include creation of policies applicable to subsidiaries, processes for handling communication between parent and subsidiaries and between subsidiaries, policies to manage the life cycle of subsidiaries, materials to assist subsidiary directors in carrying out their functions, audit processes to ensure compliance with articulated policies, technology solution for managing corporate data and monitoring compliance with governance standards, support for subsidiaries in their governance requirements, and creation of a subsidiary committee. Shout out to Camille Facey, who chairs the PSOJ Corporate Governance Committee, private sector organization of Jamaica, where they have recently revised our corporate governance code. Actually, I would argue it's a new code, Jamaica Corporate Governance Code, which includes subsidiary governance and assistance in this framework, which is modeled off of the King Code in South Africa. I commend you to that if you are interested in putting these policies in place. And if you are interested in revising your corporate governance codes, I'm speaking to Barbados and Trinidad here, and if you want to create new corporate governance codes throughout the Caribbean, this is one area which needs attention. So in a nutshell, the duties and responsibilities of directors and officers of the subsidiary and the parent should be clearly delineated, say it fast, and separated. 2, corporate records and minutes should reflect that the subsidiary board considered the particular impact of corporate transaction on the subsidiary. 3, a structure and process should be in place to identify the necessary skills, qualifications, and competencies required of a subsidiary board member. And 4, a majority of the board members should be tax resident in the jurisdiction, this is if it's a multinational, where the subsidiary is incorporated. In conclusion then, I hope that this is helpful and not just scary, but helpful in the way we go forward in subsidiary governance. And I look forward to us exploring further issues in this area at another time. In other words, I'm re-inviting myself, Kamla. Thanks again for your time and attention.
Thank you so very much, Suzanne. You know, I have to tell you, there are moments I feel like I am a sponge. I am absorbing so much of all that has been shared here for the last week, and particularly today, Suzanne. I found that there was so much learning. So you went through the fact that with parent boards, it's generally by law only if there's fraud committed, that's when the veil is immediately lifted and you can hold the parent responsible. But you have been through so many different areas, and I'm going to ask persons, if you don't mind, they may be hungry, bring your sandwich and sit here, because I'm going to hold Suzanne here for a little bit longer, because I am very sure that there are some of you who may have questions or clarifications that you want, because this was so much information and knowledge that Suzanne shared here with us. Specifically in terms of looking at how the parent can be deemed a shadow director, and so you can bypass the issue of fraud, or the parent can be held to have a duty of care, and that duty of care is linked, as she said, very much to the fact that you have put policies and so in place to ensure that there's compliance with the group-wide culture and all of that. I hope I got that correct, Suzanne. And the issue too that the fact that they're allowing jurisdictional reach as well. Suzanne, I love some of the recommendations that you made. Some of them may be very onerous to do. So for example, your very first recommendation, which is an excellent one, and which I think parent groups may be doing, but they now have to be that much more alert, which is in terms of assessing the risks involved with their subsidiary companies and the actions they can take. And your recommendation that there be a subsidiary governance framework. I want to ask you to elaborate just a little bit on that for us, and all of the corporate secretaries who are present here. I hope you took note of Suzanne's speaking of the importance of ensuring that the records and minutes show that the directors would have discussed and considered issues surrounding the subsidiary. The other two recommendations, of course, the skill and competence of the director and ensuring that the majority of the directors are residents of the country where the subsidiary is located. But so speak to us just a little bit, Suzanne, about the subsidiary governance framework to which you refer, and then I'm going to go to the chat because there's a very interesting question from Indu, I think, in there. So we'll go to Indu next.
Okay, thanks, Kamla, for giving me the hardest question. First, yeah, I don't know if you saw me as on camera shuffling to find
Oh, you know what? We could invite you again, Suzanne. Let's do a whole session on this issue of the subsidiary governance framework.
Yes, because actually I have presented on this and advised boards on how to formulate this framework. But the reason I'm also, because I'm laughing and shuffling, is because it is quite detailed, and that is why I commend persons to look at the Jamaica Corporate Governance Code, which the subsidiary governance section, or the King Code, which tells you exactly how you can go about creating this framework. So it's quite detailed, Kamla, not to dodge it, but I think I did.
That's quite okay, because I am understanding, and I think that this is reinforcing the need for us to ensure that we have a open and long conversation around that particular issue. And I always feel a sense of pride when we refer to the King's Code, because we were so fortunate to have Professor Mervyn King as our opening keynote last year. So let's go to the question from Indu Sharma. So Indu says, it's okay, so I'll read it out. She said, very interesting and up-to-date presentation on issues with respect to subsidiary governance. All the more reason to have proper governance of subsidiaries, including boards, meetings, and due consideration of issues facing the subsidiaries. It calls into question the issue of cross-directorship within a conglomerate. So can you share a little bit of your thinking on cross-directorship? Is it prudent to move away from this as far as possible?
Wonderful question. Thank you so much. You know, it was to form part of my discussion, but in the interest of time, on directors, shadow, de facto, and so on. But this concern of having nominee directors, interlocking directorships, and so on, can give rise, as we've seen in the case law, to a blurring of the lines and add to the arsenal of evidence that could suggest that that person is, or the parent company is a shadow director or a de facto director, or is responsible under the duty of care for actions of the subsidiary. Should we move away from it? I'm not sure. One of the items that I mentioned, one of the recommendations, is that you make it clear when making decisions as a director on a subsidiary board, that you are making that decision in the best interest of the subsidiary. That can be difficult. We have cases now, that live cases, where the directors are being accused of the subsidiary shareholder bringing suit against directors and officers not of this only of the subsidiary, but also because they are a director and officer of the parent, suggesting that they were really acting in the best interest of the parent. Another interesting thing, I'm going to make it difficult for myself. I'm just going to tack on to what you asked. I don't know if somebody's going to ask it. What about a wholly owned subsidiary? And that's why I cited that curious section in Australia, which says, well, if your corporate constitution says that you can act in light of the parent or act in the interest of the parent, then it's okay. I found that interesting. But again, minutes are important. Is Faye on? We talked about that the last time. You can let her know that this is a very important issue as well, to ensure that the lines are not blurred.
Yes, I know Faye was so sorry she couldn't make it today. She was telling me that this morning, she was quite looking forward to this, and she will be looking at the recording. So she
we can talk about this some more, exactly.
Yes. So I just want to invite any persons who are in the audience. If you have any questions, you can raise your hand. Judith, is it okay if I ask you to put on your mic and ask your question directly? Right, so let's invite Judith in.
Hi, good. I think it's afternoon there.
Yes.
Suzanne, that was a fantastic presentation. I'm a little bit nervous when I heard all of those, things being thrown at us, extra all over various jurisdictions, etc. But the Ben and Jerry's one was really interesting and topical for me, particularly because the issue of the shareholders suing because they felt that there were disclosure issues. And having spoken about piercing the veil and the fact that, you really want to have subsidiary governance, can you give us some insight as to how a corporation should manage the liability exposure to the subsidiary in the context of those regulatory responsibilities of a parent company?
Thanks, Judith. Nice to see you.
Yes, nice to see you too.
I'm not going to pretend that this is not difficult. It is identified as a real challenge, and even you are required group accounts, this and that, and then it's used against you. Damned if you do, damned if you don't. And so that is why my position is that with a framework, and this is going to sound, it may sound, I'll use the word bad. It may sound bad, but you have to put in place, for example, a framework which you intend to use as evidence, as a defense, to say, but we have this framework which says subsidiaries like the Ben and Jerry's are separate. However, and then you have to follow the ESG or whatever, our group-wide position is why. Again, very difficult, because you may be told, God forbid, at Grace Kennedy, that the very thing that you put in was not enough. And that is why the subsidiary ran afoul. And that is why we're coming back to you with your deep pocket to pay us up. That's the mentality. And that's the reality. But I think one step back to Kamla's request is to have a framework in place that makes it very clear that we are doing this even though we're following regulations, because we must follow the law.
Yeah.
However, we
yes.
are separating these things.
Yes. So, and that's kind of how I felt, damned if you do, but damned if you don't. But if you can make those delineations as to what you must do, and then make it clear that this subsidiary governance is separate as far as is possible, and You know, it sounds very challenging. And to me, it seems like something that you would have to develop and constantly be assessing as to what really needs to rise to the parent level as against staying at the subsidiary level.
Judith, might I also add, I don't mean to add to your distress this morning or afternoon, we're in afternoon. I don't mean to add to your distress, but also this idea of control. You want to control because you don't want the reputational damage associated. So in the case of Unilever, whether you agree with Ben and Jerry's or you agree with Unilever or you agree with the investors and some, you know, whether it was, you know, anti-Semitic or whatever, you know, and Ben and Jerry's did it out of wanting to be good corporate citizens. You know, at the same time, Unilever felt that they wish they could have controlled what Ben and Jerry's had decided to do as an independent board. So this issue of control, you want to control, but you don't want to control.
I would suggest that you absolutely have to control, because the reality is, even outside of the law, with the supply chain issues, there are so many risks from even companies that are not your subsidiaries, so long as they are your suppliers. If you are purchasing from them and they are engaged in certain activities that are either illegal or unethical, it all comes back to you as well as a company with deep pockets. And we have seen that happen in instances. And so in supply chain management, that's one of the things that we also help bring alert to our procurement officers as well. It's not just the fact that you would have to manage what happens with your subsidiaries, but even suppliers that could affect your reputation in a really tremendous way. And so the responsibility as a group to ensure that you protect that is in so many different areas. So you do have to have so many systems within the organization to be able to audit and give you a heads up.
And Kamla, you're absolutely right, but I think the devil is in the details. How do you reflect that? You know, is it in respect of a code of ethics and standards that is expected group wide? And then at the subsidiary level, you get down into the details. So they have some level of authority where they can act within an expectation as to a group wide code of ethics. So, I mean, I don't know, Suzanne, how you feel about that, because again, it's a damned if you do and damned if you don't. But I feel as if it's in the details that you really have to make the distinction between what is a subsidiary responsibility as against what is more like an overarching principle coming at a group level.
I'd say two things. One, this is where it's useful to have a director of the parents, nominee director or a director of the parent as a director of a subsidiary, where you can actually, even though they are to act, which they must, in the best interest of the subsidiary, in acting in the best interest of the subsidiary, they would be able to reach back to the policy of the parent. Secondly, I'd say to that is that, so I'm talking through two sides of my mouth, I apologize, because I'm now saying that in controlling, to Kamla's point, you actually could, then hopefully we wouldn't end up with these cases. Hopefully. If, you know, once the parent is the subsidiary controlling, is exercising some degree of control or ensuring there's some ethics, code of ethics, which applies to all. Because again, back to ESG, you need to show suppliers, you need to show that all your subsidiaries, you're not just, it's no man is an island. And so the group is being judged, you know, which is what I tell my children. I'm the parent, they're the subsidiary. Behave.
Okay, so there's a question in the chat too from Ronald Dayton Baird from PwC. She asks, how important have board minutes been in the cases you have highlighted as part of the defense that you suggested?
Okay, so there's the ongoing case. Well, it is going to trial now. I mentioned it, we had a discussion on the preliminary point, which is where a shareholder of CWC is bringing an action against it, and they wish to, they had asked the court for leave to bring this action, a derivative action, on behalf of the company for alleged wrongs done. And in that case, minutes loom large for the courts even to decide to give leave. And so I'm suggesting that, and I'm just using that because it came, you know, there's so many cases. There's one of them that highlighted minutes. I just have to look back quickly as well to decide whether or not they looked at minutes, they looked at publications, they looked at press releases, they looked at a myriad of things, but minutes was one of the things in coming to the conclusion, actually, that the parent could be exposed to a duty of care. It was the opposite. It didn't assist the company to actually, it actually damned the company in the terms of control. So just putting it out there.
Okay, all right. I don't see any other question in the chat or any hand up. So we can, okay, so there's a question that just came in. So we'll take this last question before we go, and hopefully that will give us a 15-minute break before we move into our first panel for today. And Christine Manet has asked, can this mitigation strategies be incorporated in the articles of incorporation or contractual agreements?
Okay, I would say that it is wise. It's not everything that you can put in the articles because you may find yourself limiting yourself. However, I think that is a wise approach. And the reason I say that is even because Australia contemplated the fact that once you put certain things in the articles, it may assist. So I would accept that. Contractual, I'm not sure contracting with who. You can just clarify that part for me.
Hi,
yes.
I was just, in terms of contractual agreements, I was speaking in relation to like the suppliers, where the corporation may be responsible in terms of the suppliers. So is it prudent to have these risk mitigation clauses in the contractual agreement?
Oh, that is a useful point, which I never really thought of. Kamla, what do you think of that? Because
it would help, but only so far. Because you can easily contract to protect yourself from all kinds of things. But if it is in looking at the actions, you have not ensured. And that's why now there has to be audits where you go in and check whether there's compliance with these contractual arrangements. Because especially some of these subsidiaries are very far from you. They're in different countries, different cultural practices. And we have seen that the whole, the Modern Slavery Act in the UK has to do with the fact that, you know, it's subsidiaries and suppliers in different countries who are operating sweatshops and these kinds of things. And so it's not sufficient to say, well, I've contracted, or even we have a code of ethic which says this is how you are supposed to conduct your business. You have to ensure as well, or at least demonstrate you have taken as much action as you can take to ensure that that is not happening as well.
Kamla, just to conclude on that point, I'm aware that, for example, you know, companies will not contract with certain other suppliers and so on without having an ESG policy. And so that in a way is a contractual arrangement where I'm not going to think if you don't have this or whatever, but it is a daunting task, I have to confess, for us to monitor our suppliers or persons with whom we contract. It is almost impossible to know all of their business. And especially unless it gets to a court case litigation or there's some scandal, we may not be aware, just as oftentimes the parent isn't aware of what a subsidiary is doing.
No, but I'm telling you, that is why now procurement officers are being trained to understand that that is part of their day-to-day responsibility, that you must find ways to verify the actions of your suppliers and perform these audits on an ongoing basis so that you can have some measure of confidence with the way things are done. So it does present a very daunting task for a company that's growing. I had seen Marlon's hand up. Marlon, do you still want to ask a question? And we can take you very quickly before we go back to Judith. And, you know, if we continue, you know, until the next panel, I have no objection, right? Because this is tremendous learning for us. So, Susan, I hope you are good too.
No, Kamala, I just want to support your position as it relates to ensuring that, you know, we as a company do as we want, because you really, in my view, cannot contract away your liability to anything. The law trumps whatever you try to contract yourself out of. So it's basically supporting what you're saying.
Okay, thank you, Marlon. Judith?
Yes, thank you, Marlon, as well. Just supporting you as well, Kamla, because we